Hello, hello, everyone.
Good evening. Good evening.
Thank you so much for joining. We'll get started in a few. Thank you for taking time out your wonderful evening.
All right, good evening, everybody. We'll get started in a few, and we're going to be recording tonight so that we can reshare the information for people who couldn't make it. Um, but thank y'all for being here.
What? Huh?
All right, we're gonna give it a couple minutes. I'm gonna start recording at 6:05 and we'll get started because we have a lot to discuss, a lot of information. We're gonna do some intros in the beginning, let you know who pulled this together. And we'll go from there.
Okay.
Perfect. Hey, Rob.
Hey, thanks for waiting.
Absolutely. All right. We can get started.
All right. Well, thank you everyone so much for joining us this evening. My name's Uganda Sample Jones. I'm the owner of Empower All. We are a community engagement business. Our job is to be really nosy, connect with some subject matter experts to get the information to our community. We truly believe in educating to empower. Is the transformation that we need. I thank you so much for taking the time out to join to get this information. Make sure you're sharing it. We have the one and only Miss Sheba Williams. She is my partner in crime in the General Assembly. I love running up and down the General Assembly with Miss Williams. I can't keep up with her, but when it comes to criminal justice reform, where we need to be, she is my go-to person. A remarkable young lady, and her organization is called No Left Turns. So again, I want to thank you so much. I want to get out the way because there is a lot of great information. Rob as well. Thank you for joining us, Miss Williams.
Hey, y'all. My name is Sheba Williams. I am the founder and executive director of a Richmond, Virginia-based organization called Nolef Turns. We provide direct service for individuals who are impacted by long-term incarceration. We also do some policy and advocacy work, hence Rob is here. Um, we worked on this expungement bill in 2020 special session. It was passed in 2021. It was scheduled to go in effect July 1, 2025, but our lovely administration pushed it back a year. So July 1, 2026 should be our start date. And I'll pass it to Rob.
Hey all, Rob Hogenclass. I'm the executive director of Justice Forward Virginia. We are a public defender-led criminal justice reform advocacy organization. We were started in 2017 and pushed for many of the reforms that people may have heard about from 2020 and 2021, like probation reform, capping jail time for people who got technical probation violations, ending mandatory jury sentencing, abolishing the death penalty, decriminalizing and legalizing marijuana. We worked with a lot of different organizations on that, including Sheba, um, and ending most pretextual policing in Virginia. So having a dangling object hanging from your rearview mirror is no longer a reason you can be stopped. That was us. So happy to be here. As Sheba said, she and I have been working together on this since 2020, and we're happy to say that it will finally go into effect next year. We were hoping for this year, but it's going to be next year. So I am going to try and share my screen and get started. Let me see if I can get this. Apologies, y'all. Had to wait for my wife to get home from work. So she just got home about 2 minutes ago. And there, can you all see my slideshow now? Okay, great. Thank you. So the state of record clearance in Virginia, we're going to talk about two different kinds. People might be familiar with expungement. And then we're also going to talk about record sealing. We're going to explain how those two things are different, who qualifies for which one, and how you go about that. So this is kind of the outline. Why do criminal records matter? What is record clearance? Expungement versus sealing, the different types of sealing. What does it mean to have a sealed record? When does that start? And some other important provisions in the law. All right, so why does it matter? I always defer to Sheba on this one.
So, many of you know, or maybe you don't, a criminal record has never been able to be hidden from public view in the state of Virginia, except in the case of a non-conviction, which means things you were found not guilty of, things that you were acquitted of, some no process, depending on the jurisdiction, the Commonwealth Attorney's Office, and what the circumstances were. I have been impacted by this issue for a very long time. This year makes 21 years since I was wrongfully convicted of a crime in 2004, but it didn't start then with me. In 1999, my sister was arrested for something she did not do. She spent 6 months in jail and she was ultimately acquitted. And then we found out that she had to pay $98 per charge. She had to be fingerprinted again, and she had to go back before a judge and ask for permission to have this thing removed from her record, even though she was not found guilty. And I was enraged and I was like, we have to do something to change this. I don't know what we're going to do. I don't know how the process works, but started doing some research. The late Congressman Donald McEachin pushed legislation heavily before he left the Virginia state legislation to get this done. Was unsuccessful. There, some people here who've worked on it, various different expungement bills in the past, and we were never successful. During the 2020 special session, we were in a pandemic, the murders of George Floyd, and so many others. Made lawmakers have a coming to Jesus moment and say, hey, we have to do some real criminal legal system reforms. And that doesn't happen often because in the criminal legal system work, we are often the people who they say, oh no, they don't deserve opportunity. They don't deserve good jobs, good houses, access to different things. There were so many other nuanced things that happened. My sister, even though she was found not guilty and she was eligible for expungement, it took a very long time for her to want to go back into a police department to be fingerprinted because she felt it was humiliating for a thing that she was found not guilty of. Now, I, on the other hand, have this conviction. And even though I was wrongfully convicted, if you look at it on Virginia State Police background check, it is guilty. And I lost jobs. I was not allowed to chaperone my kids on field trips. I was not allowed to answer the question on my college application. I did ultimately like appeal and go through college and graduate from Norfolk State. But before we had a ban the box on college applications, you had to answer a question about your background. I am a licensed barber, mobile stylist, loctician by trade. I lost my barber's license for 16 months because they have a 20-year look back period that asks about, have you ever been convicted of a crime? Almost every application in life asks about a criminal record. So housing was affected, and you all who are here know that if you don't qualify for public housing or income-based housing, which happens a lot of times when you have a record, you are typically spending more than 30% of your income on housing. So that was an issue. And that's really how I started to learn the law. And we realized that Virginia had an expungement bill on the book since 1975. They did a change in 1977 to remove the things that said, we know that this is an injustice to people, but we're not going to openly admit it on a public document. But when it came time to make sure that this bill passed in 2020, there was a problem. Virginia State Police said, hey, we are working on MS-DOS. I don't know about y'all, and I don't know how old everybody is, but that's probably older than me. And they needed money to upgrade their system. And they also said we need time to upgrade our system. They said 4 years. We were like, 4 years is ridiculous, but we talked to some experts at Code for Charlottesville and some other people around the country, and they said that was on par to make this happen. So that's how it happened. Rob, myself, and a ton of other people who are directly impacted, and some attorneys from Legal Aid Justice Center formed the Virginia Expungement Council. We never met for about 3 years. We all met on Zoom every 2 weeks. The meetings are still active. They are actually meeting right now. I don't know how we did that, but hey, we missed a meeting. Meet every 2 weeks to strategize around educating employers about this process, educating the general public about this process, putting together rallies. We do expungement info sessions. We also do expungement clinics in the localities where the Commonwealth attorneys are friendly to this process, because not all of them are. And we have gone through meetings with the Crime Commission. We've talked in work groups with changes that could be made to this bill. And as a result of our collaborations, we were able to get the fingerprinting requirement removed, which is huge, because a lot of people who are not guilty or not found guilty just refuse to go back before a judge, just refuse to be fingerprinted in a police station again. So that was a huge win. And I'll stop there because you got to get into the new law.
Yeah. So 1 in 3 American adults have a criminal record. This is a huge issue across the country. Virginia is one of about 12 states to pass a clean slate law that's going to allow for automatic sealing of some criminal convictions. So there is a sort of nationwide movement toward helping people clear records, because as you see, 94% of employers and 90% of landlords do some sort of criminal background check before hiring somebody or allowing them to rent. Everything has become more digitized, everything has become more sort of automatic. And so it is just, par for the course for employers and landlords to be doing background checks and filtering people out without even talking to them. Shiva and I have talked to many, many people with criminal records who say, I don't even get an interview. I just, I file all these applications and they don't never call me. They never tell me why. If you have a criminal record, that is the one reason that people can discriminate against you. And that happens every day. One thing that we are talking about, first we have to talk about what is a criminal record. And there's really 2 types of criminal records that are affected by both expungement and sealing. There's the law enforcement record and there's the court record. The law enforcement record is what police pull up when they're, out there on the street, they're doing a traffic stop, or, they call in, they say, I'm interested in this person, or I've got this license plate reader and I'm pulling it up and matching it with the driver. They want to know the record of that person. That's the record they're going to pull up. And your law enforcement record, which you can get from the state police for $15, has your entire Virginia record. Whichever localities you were in when the records happen, it's going to have all of those. And that's that's confidential within law enforcement. So it's shared from law enforcement agencies to law enforcement agencies. The Commonwealth's attorney can pull it up. The police, anyone at the jail are going to be able to access that record. But the general public, employers, landlords, they're not going to have access to that record. Your court record, however, is completely public. So both of those are sort of generated at the same time, depending on the charge. But for the most part, most criminal charges are going to generate both a law enforcement record and a court record. When I say most criminal records, there are a few things like underage possession of alcohol or reckless driving or driving on a suspended license that never actually generate a law enforcement record. They still will have the public court record though. So the public court record, of course, is held by the clerk at the courthouse. And most people who think about court records in Virginia know that you can go online, vacourts.gov, and you can see the online version of the court record that is held by the clerk. That's not a complete version. It doesn't give every detail that's in the paper court record, but it does give quite a lot of information, including whether you were convicted, what the charge was, if the charge was amended, whether it was a felony or a misdemeanor, that sort of thing, and especially what jurisdiction you were in. So all of those things are public. There's a version of it that's online, which makes it really easy to access. So when I'm talking about criminal records, we do have to distinguish between the police record and the court record. And then when we talk about the types of record clearance, expungement versus sealing, expungement in Virginia is only for non-convictions. So if you had your case dropped by the prosecutor, if you're familiar with nolle prosequi, if the case was dismissed and it was never going to be brought back with prejudice, it's called, then you can get an expungement. And also, if you were tried and you were found not guilty, those are the various types of charges that are eligible for expungement in Virginia. That does not include any kind of conviction. And that's why this record sealing law is such a big deal, is because for the first time in the history of Virginia, people are going to be able to seal conviction records. And then also if so-called first offender, deferred dismissals, those will also be eligible for sealing. Those are not eligible for expungement. They will be eligible to be sealed. And then there's going to be some non-convictions that will also get sealed. We'll talk about that a little later. All right. So what do they do? Both expungement and record sealing remove that court record from public view. And that's the important thing, because that will mean that almost all employers, almost all landlords will not have access, will not be able to see a sealed record, will not be able to see an expunged record. It's as if it never happened for when you're applying for housing and when you're applying for a job. So Shiva talked a little bit about expungement. I'm not going to go through all of this, but I will say, as far as the process goes, it does require you to file a case in circuit court. So there's a few of our organizations that have information on how to do this. We can share the Justice Forward Foundation website, which is a resource page for both expungement and sealing. Takes you through the process. The Legal Aid Justice Center also has some information on how to file an expungement. But it does require filing a petition in circuit court, and then you have to show why continuing to have the record would be an injustice to you. And so, as Sheba mentioned, when we do these clinics in places with prosecutors who are amenable to expungement, they don't require this. They don't require a court hearing. So they'll just sign off on the orders, and That's really helpful to getting people the expungements they want. But in some places, prosecutors will require you to come to court and show why this non-conviction record is a problem for you. Expungement is not automatic, at least not yet. So in when your record, when you're in court and your case is dismissed or you're found not guilty, right now that charge still stays on your record. And that's the reason we have that 1977 expungement law, is so that people can go back into court and get those charges that they were found not guilty of, or that were dismissed or dropped, that they can get those expunged. Under the new sealing law, when you're in court, and at least with misdemeanors, when the case is dismissed or you're found not guilty, the judge has to automatically remove that from your record. So going forward, once the new law takes effect next year, when people are found not guilty or the charges are dismissed, then those cases for misdemeanors, those cases will be sealed. For felonies, the prosecutor is going to have to agree to seal them. And if they don't agree, then you have to go through the expungement process. So once a record's expunged, it's only accessible by a court order. There's only a couple of reasons why an expunged record could be looked at. That's for active criminal investigations. A prosecutor can ask a judge to let them view an expunged record, or if you apply for a job as a police officer, then the employer, the law enforcement agency, could look at your expunged record. But after 3 years, those records are destroyed, so they will no longer exist, and no one will be able to access them. There are 2.5, this is the last data I have from the Crime Commission in 2020, 2.5 million individuals who have police records in Virginia. That's 2.5 million different people have police records in Virginia, but only about 4,000 get expungements each year. So the petition process is a barrier, and it keeps a lot of people from clearing their records. Sealing. So the new record sealing law will allow people with certain kinds of convictions and deferred dismissals to remove those from public view. There are, unlike with expungement, which is pretty much open to everybody, there are eligibility requirements under the sealing law. And this law is complicated. I mean, we will start to try and explain it tonight, but I have to say that, having read this thing probably dozens, if not hundreds of times, I am still finding things when I go back and look at it. It is complicated, and it's going to be hard, I think, for a lot of people to figure out whether they're eligible or not. So low-level felonies, generally speaking, low-level felonies and most misdemeanors are going to be eligible for sealing. In order to seal a record, you have to have gone without any new convictions for 10 years to seal a felony, and for 7 years to seal a misdemeanor. So somebody is convicted, July 1st, 2015. If that's let's say it's a possession of cocaine, and then they don't get any new convictions, and it's July 1st, 2025, they've gone 10 years, then they would be able to seal that felony. If you get a new conviction in the meantime, then the clock would start over, and you'd have to go 10 more years before you could be eligible to seal that. If it's a misdemeanor conviction you're trying to seal, then it's 7 years, not 10. If you owe victim restitution in the case, so in a lot of larceny cases, for example, And larceny is another felony that will be eligible under the sealing law to seal. If you owe victim restitution, say to a store or to the person, you have to pay all the restitution before you can seal the case. That does not include court costs. It does not include any criminal fines. You still owe those, but you don't have to pay those to seal the charge. But you do have to pay any victim restitution that's owed. I saw there were some questions or there's something in the chat. I can't access the chat. Do we?
So it says, you said after 3 years, it's removed from public view. So no, once the record is approved through the judge, through the courts, it'll be removed from public view. And that,
Right. Yeah, after 3 years, the record is completely destroyed, meaning no one can get access to it. That's for expunged records. So it's removed from public view once the state police confirm that the records have been expunged, but it is completely destroyed after 3 years. So expunged and destroyed are a little different, but the main thing is once you go through the court process and the state police confirms that all the police records have been expunged, it's removed from public view. 3 years later, they physically destroy the record.
so
Thank
the, oh, sorry. Go ahead.
Oh, I was just saying thank you. Sorry.
Yeah, no problem. I see the next one now.
Question. You can see it.
Yeah. If a felony from 15 years old and every dollar owed has been paid, but the felony is high, you still may not be eligible for sealing. So I'm guessing what that means is, depending on the charge, it may not be eligible. So what the law says is that certain class 5 and class 6 felonies and larceny felonies are eligible. What do I mean by class 5, class 6? That's up to 10 years for a class 5 is the max sentence you can get. Virginia classifies from 1 down to 6. There's also some unclassified felonies. But class 5 is from 1 to 10 years is the sentence, and class 6 is 1 to 5 years, and then larceny felonies, which are unclassified, can go up to 20 years. Those are the three types. Those are the sort of lowest level charges, lowest level felonies, and those are the types of felonies that are going to be eligible under the sealing law. Now, I say those types. Then this year, the General Assembly went in and carved out a few hundred offenses that they said should not be eligible for any type of sealing, even though they're class 5 and they're class 6. They didn't touch the larcenies, but they went into the class 5 and class 6 and said, if it's a violent crime, if it's related to domestic abuse, like stalking or violation of a protective order, domestic abuse, assault and battery on a family or household member, DUI, various sex crimes, various election fraud, anything to do with mistreatment of an animal. There are a whole bunch of exceptions. That's why we made the resource page that someone has Sheba put in the chat. You can see the list of every ineligible offense. We didn't put the eligible ones on there because there are thousands of crimes in Virginia. We put the ones that are ineligible to help people who might be able to go and look and see whether their charge is ineligible. If it's not on the ineligible list, then it would be eligible, assuming it's a class 5 or a class 6 or a larceny.
The next question says, for a felony to be sealed after 10 years, does it have to be after conviction or after probation?
Yes. So if what the law says is it's 10 years from conviction or release from incarceration, whichever comes later. And then this year they added, if you are revoked while on probation, it would be from the date of the last revocation or the release from incarceration after the last revocation. So that's a little confusing, but 10, so could be from the conviction date. It's going to be whichever one comes latest. The conviction date, the release from incarceration, if you were incarcerated for the conviction, or if you get revoked from probation, from the revocation date, or if you get revoked and you get an additional sentence of incarceration, then it would be the release from incarceration on the revocation. You'll notice one thing I didn't say, and I looked this up at our last info session to make sure, it does not mean discharge from probation. So if you're convicted and you're out and you go through and you complete however many years of supervised probation and you are never revoked, it goes back to the conviction or release from incarceration, whichever comes later. It's not necessarily when you're released from probation. It's your conviction date, your release from incarceration.
9 more years to wait, bro.
I'm sorry.
Sorry?
What did you say?
Hello? Oh. No.
We can't hear what you're saying.
Nothing.
Okay. Okay. So on to the next one. So the kinds of record sealing under the new law, because there are a few different types of sealing. One is going to be by petition. This is going to look almost identical to the expungement process that we have under current law for non-conviction records. You file it with a petition. The Supreme Court is working on the new form. They should have it finalized by the spring. It'll look similar to expungement, and it will say, record sealing. It does not require an attorney to file this, although, frankly, I think one would be helpful. Under the new law, there will be no filing fees. So it's not going to cost anything to file a sealing petition, and there's no cost to serve process on the Commonwealth's attorney. So once you file it, you're not paying anything as far as the filing or the service costs. There is a lifetime limit to how many records you can seal. That is tied to how many sentencing events. So that can be more than one conviction. If you were convicted of multiple charges in the same court on the same day, that is one sentencing event. The lifetime limit says you cannot seal records from more than 2 sentencing events in your life. So if you have records that are more than, say, 10 years apart, and you were convicted in say 1998 and then again in 2005, 2015, they're clearly more than 10 years apart. There were 2 different sentencing events. You would be able to seal both of those. But if you have 3 or 4 or 5 different sentencing events, you're going to have to make some decisions about what charges are the most important ones to seal. Sheba, do you want to talk about that a little bit?
So our senator who pushed this bill through, who advocated for this bill for years, put in a limit on how many things you can get removed from your record. We know that like 7 cities or like Richmond, Henrico, Chesterfield are pretty close. So if you say go on a high-speed chase on Sunday and you go through Henrico and Richmond and both counties decide to charge you, those are 2 separate sentencing events. If you only get charged in Henrico and you get 10 charges, because our attorneys sometimes like to stack charges, that is considered one sentencing event. If you get charged for the same crime on different days, and like for instance, like there are a lot of times people who have substance use disorder who get multiple convictions over time. The only ones that do not count towards your lifetime limit are ones that are eligible for automatic removal, and it's only about 8 charges there. So you have to make a decision about what's most important to have removed from your record. That does not include non-convictions. There's no limit on how many non-convictions you can request to be expunged, but your actual convictions, you have to determine what is most significant to remove from your record to give you the best opportunity for housing, employment, and different things like that. So the next question in the chat is, I'm 60, I had my rights reinstalled. I have clearance to get on most military bases, but I've been unemployed most of my life. What's my next step? This is only one tool in the process. Expungement may give you more opportunity to like apply for employment if that's what you choose to do. But this particular process does not cure all of the issues that come with the collateral consequences of the criminal legal system. It is a new step, and it is something that gives more opportunity because employers, housing managers, and different things like that will not have the ability to see this thing on your record. And we know that a lot of people say, oh, we do things on a case by case basis and we don't look at this thing. Well, if you don't look at it and you don't use it as judgment, then you don't need to have access to it. And that's what the sealing process does. As far as like next steps, that's a separate thing from this, outside of if you don't have the ability to remove. But you know, the expungement process should give you more opportunity. The next question is, do you have the list of automatic removal charges? The list is on the website. I posted a little bit earlier. I can share it again.
It's also on the slide that I have up.
Oh, perfect. That is also perfect.
Yeah. So, so the only charges that will be sealed automatically are all misdemeanors, and it's just a handful of pretty common misdemeanors, I would say. So petty larceny, concealment, which, concealment is when you're hiding something within a store, but you haven't necessarily crossed the register yet, but you're intending to take you stuffed it into a bag or something. So both of those, disorderly conduct. There's 3 different types of trespass, whether it's by, it was posted trespass or you've been barred from somewhere. And then misdemeanor possession of marijuana with intent to distribute. Since we legalized marijuana in 2021, marijuana offenses have changed a little bit. It used to be that misdemeanor PWID was anything over half an ounce. In 2020, in the decriminalization bill, that changed to 1 ounce. And then in 2021, of course, we legalized adult possession, but we kept the charge of possession with intent to distribute marijuana because you cannot sell marijuana in Virginia for now. That may change as well next year. But the big thing so misdemeanor possession with intent to distribute will be sealed automatically. And these will all require, all of the ones I mentioned, petty larceny, disorderly conduct, trespass, misdemeanor, marijuana, PWID, all of those still require that you go 7 years conviction free after that conviction date. If you do that, then they're sealed automatically. You also can't be convicted of some other type of charge on the same day that is not on this list. So if you get convicted of misdemeanor PWID marijuana, and you're also convicted on the same day of obstruction of justice, for example, then your charge would not be sealed automatically. You would have to petition. It'd still be eligible. You just have to petition. It won't be sealed automatically. Marijuana possession, however, whether you were convicted, whether you got your conviction or your charge deferred and ultimately dismissed, Or if you were found, you went to trial and you were found not guilty, all of those marijuana possession records are going to be sealed automatically when this law goes into effect.
If I, if
So,
I can add that, like the cannabis possession is a very complicated thing because in 2020 we were told these things will be automatically removed from your record. They won't show up, and we still see them on the court record. Virginia State Police has stopped reporting them, but there's different systems on the Virginia State court record. It's always still eligible. In 2026, October 2026 is when automatic will be started to be removed. July 1, 2026 is when the petition base will be started to be removed. But a lot of people say, oh, this should be removed from my record. And I still see it when I log into the court system, but it's not showing up on the Virginia State Police paper. The state is ridiculous in their process. We also worked on cannabis legalization and things like that. And they just kind of dropped the ball on removing those things from each record. So in 2026, all of that should be taken care of if we have faith in the state of Virginia. All right.
all right, some other types of, and there was a question about, so does that go for shoplifting? Shoplifting, they don't call the crime shoplifting, but in court we call it shoplifting. It's shoplifting, petty larceny, concealment. These are all just different words for basically the same crime. So yes, as to misdemeanors, those are the ones that are going to be sealed automatically. But felony shoplifting, so that grand larceny, anything over $1,000 or before, was it 2018? Yeah, the amount has changed over the years. It used to be $200, then it was raised to $500. Now it's $1,000. That threshold. Anything over that is grand larceny, and those will have to be done by petition. Can it be sealed or expunged? Again, the difference with sealing and expungement is for non-convictions. So those are cases that were dismissed with prejudice, cases where you're acquitted, where you went to trial and were found not guilty, or cases that were dropped by the prosecutor, nol prosequi. If you had your charge deferred, like if there was the judge made a finding that the evidence would be sufficient to convict you and deferred it, and you did some community service, you had to pay restitution, and then it was dismissed, or if you were convicted, those are the records that we're talking about for sealing. So the difference between whether it's sealed or expunged is not based on the charge. It's based on the disposition, what happened in the case, whether you were convicted or not, or if you had a deferred disposition or not. Okay, so some other types of automatic sealing under the new law. If you have never had any convictions in your life and you have not been arrested in the last 3 years, they are going to seal whatever charges you've ever had on your record. So if you had charges from 10 years ago and you were found not guilty or they were dropped, and that's the only thing on your record and you just never went through the expungement process, they're going to seal those records automatically when the new law takes effect next year. So for people who just never gone through the expungement process, but they've never been convicted of anything, those records are going to go away. Others, and I mentioned this one earlier, but it's worth saying again. When you're in court and you have a trial and the judge says, I'm dismissing this, or I'm finding you not guilty. If it's a misdemeanor, those records will be sealed right then and there, unless you, the person being tried, object. If it's a felony, then it's up to the prosecutor. And if they go along with it, it will be sealed right then and there. If they don't, then you'll have to go through the expungement process. You have to file a petition to get rid of it.
Please don't object. if please don't get in court and object to having it. A lot of people ask, like, why would someone object? It is a very important thing in a immigration hearing, a lot of times for people to keep records of certain things. But most people are like, who would object to that? In immigration hearings specifically, or like child custody, domestic violence cases, sometimes it is important to keep those records. So sometimes people will object for their own benefit if they're trying to get a certain thing accomplished. But if it is just the judge has agreed not to prosecute you, or please don't object and say, no, I don't want this. Know exactly what it is. But if you have the opportunity to have this removed right on the spot, absolutely have it removed right on the spot. A lot of people do ask, like, why would somebody not have it sealed? And there's like a couple of specific cases where people actually need the record to prove that it wasn't one thing or the other. Like I can say, for example, I used to work at a group home, and when I first got hired, they did a federal background check. They did not have an issue with my felony, but a contempt of court charge showed up on my record. I ended up having to call the clerk of the clerks in Richmond, and they found out that someone with the same name had a contempt of court charge in case that day. Because I do a whole lot of things and I play a whole lot of games, but I don't just go up showing to somebody else's court case, causing records and getting contempt charge. So the clerk of clerks had to write a letter on my behalf to have the thing removed from my record, but the job would not hire me until that got taken care of, got resolved. And that was a thing that we had to get the clerk to go somewhere off site to pull my paper record to make sure that I wasn't that person. So there are instances where you'll see people want to have access to their own record, which is really important in like cases of mistaken identity and different things like that. So and since I just kind of thought about that, the only time that people would be required to get fingerprinting done is in the case of identity fraud or mistaken identity, just to prove that they are who they say they are, and this thing does not belong on their record. But everything else, the fingerprinting requirement will be removed in 2026.
What can be done for an erroneous domestic violence charge filed 30 years ago? He was never convicted, but it's a barrier to getting a firearm. So
Non-conviction.
If it's, I guess my first thing would be get the state police record. So you can pay $15. You fill out a form on the state police website. It's called the SP 167. It's just if you go there and say, I'm looking for how do I get my own criminal record? You can obtain your own criminal record from the state police for $15 and the cost of a notary. And you, once you fill out the form, then you print it, you mail it to the state police with the notarized signature form and $15. And then it takes them about 3 weeks and they'll send it back to you. And that will show whether it was a conviction or not. If it's not a conviction, I don't understand why it would be a barrier to getting a firearm, because there is a federal law that says that if you're convicted of misdemeanor assault and battery on a family or household member, misdemeanor domestic abuse, you cannot possess a firearm under federal law. There's a newer law in Virginia, but it doesn't apply to older convictions. So unless it's a conviction, I don't know why, unless it was a deferred dismissal. So getting the state police record will help clear up what the actual disposition was, because if he's not able to get a firearm, I'm not sure.
That is a
I don't
non-conviction.
understand that it's not a conviction, because if it wasn't a conviction, it shouldn't be a barrier to getting a firearm.
I think an important thing to note, like when you're looking at your own record or when you're trying to look at it, there's a charge that you are arrested for or charged with in the beginning. A lot of times when you go to court, the judge can change a disposition. Sometimes it'll change from a felony to a misdemeanor. Like a lot of times, traffic court. Like if you go to traffic court and you get a speeding ticket or something like that, sometimes the judge will ask all the questions like, were they cooperative, blah, 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 blah. And they'll say, well, we're going to not defer this, but make this a improper equipment charge, or take it down to speeding 1 to 9, or just make it a lesser charge so that it doesn't hit you as hard, like on your insurance and things like that. That's what happens a lot of times with your arrest. A lot of times, if you go into court, it will get changed to something that is less severe. Um, but people have to know, like when you look at your Virginia State background check, that'll tell you what you were originally charged with and then what the disposition was. It has both of them on there, and a lot of times um, people get confused. Like we used to see a lot of times where housing managers would deny based on the original charge and not the disposition. And then if you'd appealed, they look at it and say, oh, well, you didn't get convicted of a felony. So it can be complicated, but absolutely get a copy of your record to make sure that things are what you say they are. And then a lot of times what a deferred disposition is, you may be a first-time offender, you may be in a specialty court like a drug court or veterans court or mental health docket, where if you complete certain terms, I think Rob said earlier, if you do community service or you go to a VSAP class or you complete whatever terms the judge says is sufficient, they'll say, you stay out of trouble for this amount of time, we'll remove this thing from your record. A deferred disposition is still considered a conviction. So sometimes that's what happens. Even though it's removed from like the record, technically, it's still considered a conviction. So that may be the issue.
Another route, if you know you're just dealing with one charge in particular, you can go to the courthouse where it was, and but that's only going to work if it's a felony. So misdemeanor records, even convictions get destroyed after 10 years. So the courts, yeah, the reason we keep saying the state police is because if it's really old, only the state police is going to have the record, unless it's a felony. If it's a felony conviction, then a circuit court would have it. But for most of them, yeah, if it's 30 years old, you got to get the state police record.
Yeah.
All right, the effects of sealing. So unlike expungement, which is basically inaccessible to anybody once a record's been expunged, there are some reasons why sealed records can be accessed, and that's because convictions have more consequences than non-convictions do under the law, particularly when it comes to interacting with federal law. Federal law does not care about record sealing in states. Federal law wants access to your record, whether you've sealed it under Virginia law or not. And so if you're applying, for example, for a national security clearance, or you want to work at the FBI, or you want to work at a bank, which is regulated by the Federal Deposit Insurance Corporation, they want access to that record. If it's been sealed, you have to they're going to unseal it and they're going to get access to it. So when I'm saying, you might have noticed when I say most employers, most landlords, if you are applying to public housing, which is regulated by the federal government, they're going to be able to access the record even if it's been sealed. So the effects of sealing, though, are still very powerful in that anyone who goes up to the courthouse and asks for the record is not going to be able to get it. It's not going to be on the online court system. You're not going to have to disclose it to private landlords or private employers. You're applying at 7-Eleven or Target or Walmart. Those jobs cannot access a sealed record, and they cannot ask you about a sealed record. Doing so is actually a crime for them. So it's important to know that it's protected from the private institutions as well as local and state governments. So if you're applying to a college in Virginia, or you're applying to work at your city maintenance department or something, those entities also cannot ask you about a record once it's been sealed. It is important to distinguish, and Sheba's done a little bit of this already. These are different. Sealing a record is a different process from getting your rights restored. It's a different process from pardons. The governor in Virginia right now does all the pardons. The governor does restoration of rights. That may change next year with a constitutional amendment on the ballot, if we get there. But still, for right now, only the governor can restore civil rights. But the governor cannot seal your record. Only a circuit court judge can seal your record. And those have different effects. So when your rights are restored, you get to vote. When your rights are restored, you can hold public office. You can serve on a jury. When you get your record sealed, it does not mean your rights have been restored. So you can get one without the other. You could have your rights restored and be able to vote and serve on a jury, but your record could still be public. Or you could get your record sealed, which means employers and landlords would not find out about it, but you would not be able to serve on a jury. You would not be able to hold public office until you get those rights restored. So they're different processes. A judge does the sealing, the governor does the restoration of rights. Same goes for having a firearm. Judges have to restore your firearm rights. That can only happen after the governor has restored your civil rights. It's not dependent on your record being sealed. There are lots of different reasons why a sealed record can be accessed. Certain professions, like if you apply to be a paramedic or a law enforcement officer, in child custody cases, judges are going to be able to consider records even if they've been sealed. If you're charged with a crime in the future and your record was sealed, the prosecutor is going to have access to that. That's going to matter, and the prosecutor will be able to bring it up if you're, asking for bail or at sentencing. It could influence your sentence. And then, as I mentioned, as required by federal law. So, if you're working for a company that's regulated by the federal government, like a bank, or if you're applying to like the FBI or a security clearance, military, the federal government can ask about sealed records. Okay.
Well, the question in the chat is, will the potential employer, rental property, et cetera, know if your record has been sealed? So once your record has been sealed, they will not know that there has been a process. And it's up to you to know when your record has been sealed so that you don't have to voluntarily disclose it. Once it's been sealed, you're not under any obligation to give them that information, but you also have to know that just because I submit my paperwork, it doesn't mean that the turnaround is right when I submit my paperwork. Sometimes judges take some time to actually complete the process. So you have to be cognizant of like when your record was actually sealed. And from that point forward, you're not obligated to give them that information. So no, they don't have a way to know if a record has been sealed or not. When they pull the background, it should not show up and you should not be giving them that information voluntarily.
All right, when does record sealing begin? July 1st, 2026. Originally, this was going to take effect next week, but that because of the changes made to eligibility, because of all the offenses that were removed, the governor and the General Assembly pushed it back 1 year. It will take effect July 1st, 2026. And then automatic sealing will begin a few months later. It's going to take a little bit for the state police to send the lists of charges to the courts for automatic sealing and for the courts to get those charges automatically sealed. But I expect there will be several 100,000 charges automatically sealed once that process gets rolling. It's going to be fun to see the numbers. In Pennsylvania, they've sealed or expunged millions of records at this point. They were the first state to enact a law like this back in 2018, I think. And they've been just hugely successful in sealing just millions of criminal records, helping lots and lots of people. Some other important provisions. So when a record is sealed, a new provision in the 2025 law is ancillary matters will also be sealed. So this was not clear in the original law that passed in 2021. If you if your probation was revoked, if you failed to appear at any point and had a new charge for failure to appear, if you appealed your bond, anything that was associated with that original felony case, all of that gets sealed at the same time your felony conviction gets sealed. This is really important because a lot of times there's an original case number and then it will say like -01, -02, -03. All those dashes 01, 02, 03 are going to get sealed if you seal the underlying felony. If this hadn't been added, then there would be some stuff hanging out there and people would be able to figure out that you had a felony conviction. So this is a really important addition. We pushed for this back in 2022, but there was a different legislature at that time and they were not interested. This is a good thing. The 25 legislation also eliminates the right to counsel. This was Senator Saravel's idea from 2021 that everybody who wanted their records sealed would be able to apply for an attorney if they couldn't afford it. The problem is there aren't enough attorneys to do that in Virginia. They're just, the pay is so low. It was going to be like $120 a case to do one of these, and there just are not attorneys available to take all these cases. The state bar is looking at options under this law. There's an enactment clause in the law that gives some. The state bar is going to sort of investigate this and see if there's some potential solutions to hook people up with pro bono lawyers. But that is still very much in the works. We don't know what that's going to look like if there's going to be anything there. So the right to counsel came out. No filing fees, no service fees for filing the sealing petitions. So that is no longer a barrier. As Sheba mentioned, fingerprinting will not be a requirement. That was something we pushed for in 2021. And it will no longer be a requirement in expungement either. So people expunging their records will not have to get fingerprinted. This kind of goes a little bit back to Richard's question about, do you have to tell people about, or will the employer or rental property, et cetera, know if your record's been sealed? In some cases, there are private companies out there who are buying and selling bunches of criminal records. They make money off buying up records and then selling them. They're called business screening services. And under this new law, those companies, which the problem with them is they will have these records, and then if people expunge or seal, they don't update. Well, under the new law, they're going to have to update. They're going to have to register with the state police in order to do business in the Commonwealth of Virginia. And then if you find out, like you say you go through the whole sealing process, and then somebody some employer says, well, you got a record that showed up on your background check. You didn't tell us about that. First of all, get a copy of the ask who did the background check, and then you can write that company and get a copy of that background check so you can see what the record is. And then people who have those records show up will be able to contact the company and get those records removed. And if the company doesn't want to do that, then you can sue them for damages under the new law. And you can get, I think it's $1,000 in damages from any company that doesn't remove your record when you ask them to. Alternatively, the Attorney General can prosecute can sue them for damages as well. So that's going to be a big change. There's a lot of folks who've had problems. I know I've done this work in another state where people would say, I got my records expunged, but these companies, they still have them. And so when I'm applying, the records are still showing up. I think Virginia has figured this out. This is a provision that not a lot of other states have, and it's going to be really great to enforce against these private companies, because when you're expunging and sealing, you're expunging and sealing your official government records. You're not it's not touching those private companies who have copies of them. But this business screening services portion of the law will hopefully take care of that. They did add this year a look back date because clerks are going to be spending a lot of time sealing records. They wanted to put a date before which people will not be able to seal convictions. So anything before January 1st, 1986, which is when circuit courts started to digitize their records, anything before that cannot be sealed. So if you were convicted in 1978, sorry. And the idea was both, a practical one for clerks. They don't want to have to go. A lot of these records are stored off site. They're paper. They're, probably crumpled and yellow and old in warehouses. But also just sort of the practical reality of, if somebody had a record from 50 years ago, they're probably not applying for jobs. So for better or worse, that's the date we ended up with. It may be changed in the future, but when the law takes effect next year, we'll only be able to go back 40 years. Traffic infractions, so non-criminal traffic cases like speeding or running a red light, those are going to be sealed after 11 years by DMV. So DMV has a role here, which is they're going to seal all traffic infractions after they're 11 years old. And those are also listed on the online court's website. So that will mean something. Here are some resources. Sheba's posted our link in there a few times. There's her website. The Crime Commission has had a very large role in drafting this legislation and in explaining it. They've got lots of reports on their website about how this law came to be the way that it is. They're going to also be putting out some frequently asked questions shortly in the next couple of months, I think. So that will be a place to watch as sort of the official version of the information that we're providing. I also wrote an article about expungement and sealing that I linked to here. It goes more in depth into some of these questions, particularly with expungement and what's eligible, what's not. So I'm also happy to share this presentation with anyone who wants to do that. So I'm going to stop sharing and then I can put the link to the presentation in the.
And I can, we had quite a few people register, so I can also send it out to everybody who register after we wrap this up. Are there other questions? Hey, Candace. A big thing, so Virginia Expungement Council still exists and needs people to support expanding access. We don't know if expanding will happen in the next couple of years, but like if you listen to how long we've been working on this, 5 years in the making, this happened and for this bill. I've been working on this for a long time. And we know that it impacts people's lives in a personal way. Like obviously my conviction is 21 years old and I have been self-employed and I, run an organization and things like that. So it won't mean as much, but I have a friend who I've talked to about what it will mean to get this thing removed from her record. And she always equates it to getting her name back and not being a number for the state. So we need people to also advocate for expansion, fight for further change in the law. And it may not be a thing that happens in a year. It may not be a thing that happens in the next session, sometimes this is a long haul, and we need people who will talk to their legislators about what it means to have a record seal. I caution people with like what you share online and like what you share with people, because if the goal is to remove the record, we also don't want you recording a video and saying, hey, this is what I was convicted of. Speaking in general is just as effective. Speaking in private, you can share those things, but don't put yourself in a position where you're posting something online and then going to be, removing it from the court, and that digital footprint is still there. So, we do an advocacy training around getting involved, like the ABCs of General Assembly and policy making and advocacy and things like that. If anybody is interested, I'll send everything to everybody who's registered. But we also need people to advocate for further change. We also need people to talk to their legislators about what this means. The federal policy hasn't happened yet, but it is definitely something that Clean Slate Initiative, which is the national partner on this, has been working on. The cannabis thing, and I'll tell y'all, like, in my personal capacity, I have been trying to figure out the expungement piece for Virginia for years, since I found out how ridiculous the process was for people who have non-convictions, and then realized that there are things that people were being like denied access to opportunity for that were non-convictions. I just so happened to get this wrongful conviction, which sparked something that made me like, fight. But it does impact people's everyday life. Like we know about we know about housing, we know about employment, we sometimes know about college applications. We don't think about not being able to chaperone your children on field trips, not being able to volunteer at certain places, not being able to adopt your family members by kinship should something happen to your relatives. We don't know about like the nuanced things that keep a person from having access to things. I work on a lot of different things where the barrier crimes laws, it took years. It took years to get a small step in the barrier crime law. So nonviolent drug convictions, now people will be eligible to be peer recovery specialists, right? That's been something that's been fought for 2 decades. It's, well before I got involved in this. The constitutional amendment on right to vote is something that I lead a coalition on, and Rob is a part of. All of these things matter in quality of life. This is one piece of the puzzle. So I keep going back to the question that was asked earlier, what's the next step? All of these things work in tandem to make sure that people have good quality of life. And we need people to like work alongside us, even if you're just sharing the information. Everybody has a role in like pushing this forward. But if you do nothing else, talk to the person who represents you and let them know how important this is, because there are some legislators who do not believe. There are some legislators who say this does not impact my constituents. And we pulled data. Code for Charlottesville worked on scraping 20 years of court data a couple of years ago. And the number one constituency who had new felony convictions in the past 20 years was Bath County, Virginia. That is a rural red leaning locality. And the former representative said, we don't need this. There are legislators who vote against this, who each legislator, each district, each representative has thousands and tens of thousands of people who will benefit from record sealing and expungement. So we need people to like, let that be known. So if nothing else, talk to your representative and let them know. And when people are coming to you for votes, because we got an election in November and we have an election every year, tell them what this means to you. Talk to them about what their intention is on supporting this legislation, because they make the decisions at the end of the day, and we need this to go forward. We need this to be expanded. So the charges that are ineligible right now, we want to make sure that they're eligible, because if Department of Corrections, 95% of people who go into Department of Corrections come home at some point. even if you did not go to jail, because I did not go to prison, I was sentenced to probation. Um, it makes a difference. It makes a difference in what you're able to do going forward. And we are happy to present this information because the state has not done anything to provide this information. So Rob and I, you'll see us all over the state doing info sessions, doing clinics in the localities where our Commonwealth attorneys are amenable to it. Now, a lot of people want to know, like, when can I get a clinic? When can I get a clinic? It takes a lot of coordination. It takes a lot of people to come on board to make sure that this happens. And it also, at the end of the day, takes a Commonwealth attorney who is willing to remove records without the ridiculous process of making people come into court. Now, does that mean that everybody who goes to a clinic doesn't come to court? No, not at all. But it reduces the amount of people who are going to court. It reduces the requirement for fingerprinting to be done at a police station because we bring somebody in and it's usually a university officer or a sheriff's department, so that that trauma of going back into a police station to be fingerprinted is alleviated. We bring the attorneys to the place, and a lot of them are pro bono, so they're doing this without being paid. We cover the fees and the costs for what Virginia State charges for those filing fees right now. We make sure that we partner with like a legal aid justice center to make sure that the fees are sometimes waived. But if there are fees that come up for people who don't qualify for legal aid justice services, we also cover the fees. The fingerprinting is taken care of, the background is taken care of in a clinic, but we don't have capacity because we're a small group who do all of this stuff across the state, and the administration does not support it in the way that they should. We don't have the capacity to go to every locality that wants a clinic. So we're working on it. But we do need the support. We do need people to like have these conversations and be very candid about why record sealing is important to your livelihood. Uganda, jump in.
Well, look, y'all have done such a wonderful job. I just want to make sure everyone's questions were answered. But I just thank y'all so much for bringing this important information. I know when we did our housing expungement clinic with legal aid, many people came back and asked about the criminal portion. So I know who to go to, and y'all like did an amazing job as you always do. You know, you always have the support here in Newport News, Hampton Roads. Whatever you need, the space, the coordination. I can't wait until we get our clinic, but I am so grateful for all of you. Rob, Sheba, just the work that you do is amazing, and the work that you like put in. Y'all are really boots on the ground and accessible. So kudos to y'all. Thank you so much for everything. I do want to share, well, first I want to give a shout out to Miss Dr. Atika Weaver. She's actually the chair of the Newport News Human Rights Commission. And I know we have people that come to the commission asking questions about expungement, and having resources like you to be able to connect people to is really made a difference. So thank you so much for the great work that you're doing with the Human Rights Commission, Dr. Weaver. I do want to give people a couple of things. With Empower All, we work on many different social justice issues. One thing that we have now is the big Coal Dust Kills campaign. In Newport News, we have 2 coal terminals that have been polluting our air, and also in Lambert's Point. So we're having a free community concert this Saturday at King Lincoln Park, Pickett's Beach. It is there at the end of Jefferson Avenue. It will be from 4 to 7. We have a phenomenal group, 5-star, but we also have a panel of residents that have been affected by the coal dust. Also policymaker, decision makers that can do things, and then some of the letting people know the progress. So that is this Saturday from 4 to 7. We're going to have free fish sandwiches, free Canona ices, and great music. So come and vibe with us. I would like to ask a question. Yes, sir. Mr. Is it Moshin?
Muslim Milwaukee, how you doing? Yes, ma'am.
All is well. Hello, welcome.
Well, yes, ma'am. Thank you. Well, look, I have a family. I don't know if I heard some of the conversation. I don't know if I caught it at the end. I apologize if I did, but I have a really bad one, and it's been kind of hard for me to find jobs or employment. So I want to, what do I do about that type of situation? What do I do?
When you say bad one, I'm assuming you're talking about like between like a class 1 and 4 or like a more higher level.
Yes, ma'am. So it's more so. I was falsely accused though. I don't know. It may sound like far fetched, but you know, it was actually it's like it's a sexual assault charge. So, and it's been really it's been traumatizing me. So I think at the time when my incident happened, I was mental capacity. I was like out of my mind when the situation happened. So, and when I came to and got myself together, I was placed in Central State for a while. Well, I was in the jail first. Then I went to Central State. So from there, I think I did a total of 5. I think I did 2.5 at each facility. So I've been home maybe about going on 2 years now. I do have employment, but need to find more employment because I have children, big grandchildren, my life back there. So it's been a process.
Yeah. So
Yeah.
unfortunately,
But it's trying
um,
to find,
the higher level charges and most sexual assault charges are not eligible right now. We keep advocating for them. You know how Virginia is. They are not very amenable to the things that they use for fear mongering campaigns. So, but we
yes,
keep
ma'am.
having conversations. And when as far as in the other gentleman, you got to keep applying until you get a yes.
I
I
agree.
like policy and advocacy work, but I also do direct service, and it is an uphill battle for especially when you have a higher level charge. But you got to just keep doing it until somebody says yes, and communicate your story in a way where it's understood that yes, this happened, but I also have these things to offer. Department of Corrections offers million, like not millions, hundreds of like trade programs and apprenticeship programs, right? And they're now reinstating the Pell Grant eligibility. So the state is making it so that people can get access to education and get these trades, but not being able to use them. So,
Mm,
you know, that's a place to start. But you just got
ma'am.
to keep applying until you get a yes. And you'll get a lot of no's. You got to stay encouraged. You
Yes,
have
ma'am.
to stay the course.
I'm a believing man. I do believe in God, so I do
So,
believe.
yeah, I wish I had a better answer or a
No, you
better,
did good. You did good. You did
but
good.
that's what people have to do. They just got to keep trying until they get the yes. And
Yes,
that's
ma'am.
that's a hard path. I've been down that path. That's how I ended up self-employed. But I graduated from college. I own my business, and I am also somebody who lives with a felony. So, I'm all of the above, and the determination, because it'll beat you down some days. It'll beat you down, but you just got to stay encouraged and, you know, keep going.
Yes, ma'am. Thank you
And
so much. I
thank you
appreciate it.
for like having the courage to be able to share your story. I do want to share with you, I'm not
Yes,
sure
ma'am.
what city you're in, but in Newport News, we've been working really hard to make sure that we have employers that understand the demographics of our population. And we have S23 Holdings that they're actually building, they broke ground at 14th Street in Jefferson. Well, actually 14th and Terminal. Mr. Jose Rivera is the owner, and
Yes,
the business again is S23 Holdings. They're actually hiring now. I apologize, I don't have the phone number, but they have a sign out there, and he's looking for returning citizens. He's looking for people who have blemishes and barriers, and he actually has a technical trade school that he will train you on how to do the fabrication work, the welding work, but there's a lot of great opportunities there with that business. And I did put my contact information in the chat. If you need a direct connection, I can make that soft introduction for you. There's a couple other people who will hold your hand through a employment process at Brooks Crossing. Mr. Dennis is amazing, and Art. They run the Navigating Wealth program. It is a program where you're paid $400 a week to be able to get the job skills, the workforce skills and connections that you need. So there's quite a few programs that we can connect you with. Just give me a call at that number or email me.
yes, ma'am. I can do that. Y'all some powerful sisters, man. That's all I wanted to let y'all know that too.
I
Y'all
just
tough. Just even had us all set up.
Yeah,
And
I
the
want to
knowledge that
uplift
you
the
have.
voice other
ma'am.
stuff in the chat for you as well, like
Yes,
people
ma'am.
have dropped some resources, so please like take note of that. Yeah, that, so, for everybody here and others, I am working on putting together a Virginia Justice Conference September 11th through the 13th in Richmond. The goal is to bring resources to one space, but also work on this policy, get ready for this election that's coming up, get ready for 2026 General Assembly session. We will be addressing and talking about like the process of getting things done at a community level, at a state level, and at a federal level, right? We want to make sure that people are coming to the table who are impacted by these things, because a lot of times we make moves, we make decisions, and we talk about things on a bill. And I don't live in a vacuum. Like, my experience is my experience, but I am one of, what is it, 3.6 million people with a record. Um, I'm one of many, right? So the more people who come to the table to like share their ideas and get involved in these processes and join rapid response teams, who learn how the General Assembly process works, who are able to testify or write letters or write like postcards. And if that's not your thing, adopt a daggone inmate, adopt somebody who's incarcerated to make sure that they have a connection to community when they're ready to come back home. Like, there are different ways to make these things happen, and it takes all of us to get it done. So this is going to be the inaugural event. I'm nervous, but I had a vision that like we don't always work together on these things, and a lot of people are finding out information in forums like these. And of course, we can't cover everything, but this is a place for us, and that's going to be that. It's going to be at the Richmond Convention Center, um, September 11th through the 13th. So I'll send everybody who registered the information, because I have everybody's contact there, and we'll send all of this information to you all. But yeah, stay in touch. Like, when changes happen, we want to make sure that you all know when the changes happen. Now, I got this vision in 2026 that we get as many locality as possible to do expungement clinics on July 1, 2026. I don't know how well they're going to do it because I don't have to do the work. It's the attorneys doing the work. But I want to make sure that as many people as possible can get things removed that are eligible right now. And for those who don't have the process, thanks, Candace. Um, we try to advocate for getting it expanded. I don't know how that's gonna go, but we're gonna do it. We're gonna fight for it anyway, because we
It's
didn't.
gonna happen. Once we get this information out and we get everyone that's on this call, and we're claiming 100 others to fill that General Assembly room, they're gonna change it to what we need it to be. We're speaking it into existence. So, sir, we're gonna need you to show up in January when we say it's time to go. So make sure you stay
I will be
engaged.
there. I will be there,
And you
inshallah.
as well,
My
Miss
best.
Candace.
Yeah, show up in November when it's time to vote too, because that also makes a
Okay.
difference.
Okay.
So this is important.
Yes, ma'am.
Yes.
Every piece has everything is a piece to this puzzle. We have to show up in these elections, and we have to vote for the people who will fight for what we need. And what I mean by that is no matter what it is you care about is tied to that vote. These people who are running for elected positions need to know what your needs are, what your priorities are. So when they show up to your churches and kiss the babies, ask them the questions. Tell them what your
Accountable.
Tell them what your needs are. Don't let them bring their agenda to you. Tell them what you need for a better quality of life. So when they get in those positions, when they get in office, you go to them and say, hey, this is what you promised on that campaign trail. I need you to execute this. But if we don't vote, if we don't get the right people who support this agenda in position, then it makes it harder for the advocates to get the things done. The reason why the 2025 bill, the bill change in 2025 is because some legislators felt like they should carve out. We in Virginia had the most progressive expungement or record sealing bill in the nation, I believe it was in 2021. And then they told us they needed 4 years for Virginia State Police to update their system. 2025, we're looking at, I think it's 118. I could be wrong about the number. We're looking at a lot of carve outs. And that was a very last minute change because there are a lot of lawmakers who do not believe, they do not believe that their constituents benefit. We know the data, we know the numbers, we know that there's 1 in 3 adults with some sort of record who could benefit from them. There's absolutely no way that these legislators who are voting against this and carving these things out don't know that their constituents benefit from this. So that's where we go moving forward. And we at 7:31, y'all.
Awesome. All right. Are there any other questions? All right. So Miss Sheba, Rob, again, thank you so much. Make sure y'all carve out those dates, September the 11th through the 13th. Plan to be at Richmond Convention Center. Get the information, empower yourself, and then empower others. But thank you so much for joining us this evening. This has been powerful and very informative. Y'all be encouraged.
Absolutely.
Thank you.
Bye.
Thank you.
Thank you. Wonderful job, sis. We did it. Great, great information. Great information. You, oh my goodness. You have the knowledge just right there. Like the same way I be speaking about environmental stuff and communities, right? You just be, I don't, it's so much in the weeds of like it's so convoluted depending on what conviction someone has that you don't know what route to take. It's really like case management because each case is different. So you have to find out what information or what's going on with the person, kind of do like a triage and then disperse them to the correct process. But I thank you so much for being who you are and all you do.
Absolutely. I appreciate you. And for y'all that's still here, thank y'all for being here. I've stopped recording if y'all have like offline questions.
Yeah. We
Um,
not recording no more, y'all.
I gotta stop the live on Facebook.
Yes. Did y'all get